Trump's immigration agenda has thrust the constitutional right of due process into the national spotlight. Democrats and many judges say everyone, even deportees like Kilmar Abrego Garcia, deserve this constitutionally protected right. But President Trump seems to have a different interpretation of the law for non-citizens, repeatedly questioning the constitutional right to due process.
And critics of the administration are outraged, although many supporters of the president argue that non-citizens are not entitled to the same constitutional protections. Here to break it down is Hans von Spakovsky, a senior legal fellow at the Heritage Foundation. Welcome to Rising.
Thanks for having me on.
Yeah, we appreciate it. This is a very important and timely debate to be had right now. You'll hear members of the Trump administration say, immigrants are not entitled to the same necessary due process procedures as citizens. How do you view this topic? What should the government do and not do with respect to illegal immigrants it wants to take some kind of legal action against?
Well, part of the problem here is people are confusing different kinds of government procedures, and they're ignoring what the Supreme Court's already said about this. And what I mean by that is immigration proceedings are civil matters. They're not criminal matters. It's true that in a criminal matter, if the government, for example, is going to prosecute you for murder, yeah, you are entitled to constitutional due process rights, whether you're an alien or a citizen. But when it comes to an immigration issue, if you are an alien who's in the country illegally and the government is moving against you, that's a civil matter. And what the Supreme Court has said in several cases on that issue is that if you are an alien trying to enter the country, you have no due process rights. The government can reject you for any reason or no reason. Once you're in the country, yeah, you do have limited due process rights. But again, what the Supreme Court has said is those due process rights are what Congress decides to give you. And in fact, even, for example, for legal resident aliens, what the Supreme Court has said is, in prior cases, is that due process rights means that the ability of the alien to appear before someone to state their case, whether it is in the executive branch, it doesn't have to be a judicial tribunal. And so if you look at the immigration laws, they only provide certain due process rights. You, for example, are not entitled to a lawyer from the government. The government doesn't have to read you your rights when they arrest and detain you. So your rights are limited. And in fact, there are many particular cases where the immigration law says that for example, the judiciary has no jurisdiction. So again, it depends on the alien, what kind of case it is, and their status.
I wonder, though, if that is complicating the topic a little bit, because the Fifth Amendment, as you well know, provides that no person shall be deprived of life, liberty, or property without due process of law. And the Supreme Court has held that people, regardless of their immigration status, come under the heading of person, and that therefore they are basically entitled to due process. So it seems to me there's a bit of, frankly, with all due respect, hair splitting going on in your case, when in fact the right seems pretty clear.
Well, if you want to blame hair splitting, then blame it on the U.S. Supreme Court. Because again, you're confusing a criminal case with a civil case. I mean, for example, again, if you're an alien and the government says you're illegally in the country, you are entitled to a hearing before an immigration judge, not a federal district court judge under Article 3, but an immigration judge. Immigration judges are actually employees of the Justice Department. If you disagree with what that judge says, if the judge says you're not entitled to be in the U.S., you have the right to appeal that case to the Bureau of Immigration Appeals. Again, that is within the Justice Department. The judges there are employees of the Justice Department. If you disagree with that, federal law does not allow you to appeal to a federal district court judge. Your sole appeal is to federal courts of appeals. So, for example, federal district court judges right now who are hearing cases from aliens who have a deportation order lodged against them, because they already had their hearing before an immigration judge, those judges are actually violating federal law by even considering the case.
And Hans, how about this though? I think one of the arguments that people are making is, but look at what is being done now by the Trump administration with some of these illegal immigrants. They're being detained in facilities and then they're being shipped off in some cases to a prison in El Salvador. So while I agree with you that it's a civil matter and they're not entitled to the same rights in terms of civil matter, the way the Trump administration is carrying this out, well, maybe they're saying it's a civil matter, but it resembles a criminal matter in the ultimate fate of some of these illegal immigrants themselves. Does that complicate the picture at all?
Well, again, it depends on what the status of that alien is. If there's already a deportation order that's been issued by an immigration judge, that means they've had their due process, they've had their hearing. And if what the Department of Homeland Security is doing is simply enforcing that deportation order, in other words, issuing a detainer warrant, finding that alien, arresting them, detaining them, and then shipping them out of the country, they are fully within the provisions of immigration law. And keep in mind, there's about 3 million unenforced deportation orders sitting at the Department of Homeland Security because the Biden administration basically refused to enforce those orders. But that's a different situation than an alien who is detained, who has never had an immigration hearing. That would be a different situation.
But Hans, if you're elevating the importance, or at least respecting the importance of immigration courts, we get back to the case of Mr. Abrego Garcia, who had an immigration lawyer, or an immigration judge, excuse me, say he should not be deported to El Salvador, and the Trump administration deported him to El Salvador. So even as you make the larger argument, would you at least agree that there is a problem with the administration's actions in that regard?
No, because you're not realizing something else, which is because the immigration judges in those cases found that he was illegal in the U.S., but they said, we're going to give you a one-time waiver because of his fear of a particular rival gang in El Salvador. But what you're overlooking is the fact that under, again, federal immigration law, the Attorney General of the United States has the ability to override the decision of any immigration judge or the Bureau of Immigration Appeals. And that's clearly what happened in this case. Plus, remember, the waiver was given because of the existence of one particular gang. That gang no longer exists in El Salvador. That was one of the gangs that was completely broken up by the current president of El Salvador when he came into office and declared emergency powers. So the sole ground for which this guy was not deported after being found illegally in the U.S. has disappeared. Plus, again, under the law, the Attorney General has the ability to override that decision. I've not seen anyone mention that in the press, but that's part of federal immigration law.
Going to have to leave it there. Hans, thank you so much for joining us to discuss. We really appreciate it.
Sure, thanks for having me.
Next up, is the South African government calling Trump a liar? We'll discuss and debate it. Stay with us.